Now, Justice Roberts' opinion is just an intellectual blunder of the first order. Now, why? Not because he gets the Commerce Clause wrong, which he does, but the key thing to understand about the earlier precedents, including cases that he cited, were that you could not use the Commerce Clause where you can't use the taxing power, and you couldn't use the taxing power where you didn't use the Commerce Clause. That is, it's a legal doctrine called these two things are in pari materia. That's a wonderful phrase, meaning basically they're the same stuff. And it turns out that if you go back and you look at these various type situations, if you now decide that you cannot regulate this thing under the Commerce Clause, then the tax clause has to follow with it. Now, this was developed 100 years ago, actually 90 years ago, something called the child labor tax cases. And in the pre-New Deal Constitution, what had happened was in 1918, the Supreme Court, in a key case called Hammer and Degenhardt, struck down a statute which said you could not ship in interstate commerce any goods made by any factory which at any point in its operation had violated a child labor law that the federal government had put together. And Justice Day, one of the smarter conservatives, said this is tantamount to a direct regulation of local production, which was illegal at the time, and I'm not going to tolerate it. And he was right about that because you gain a few dollars from using child labor, but you lose a fortune if you can't sell your goods into national markets. And so the coercive effect of this was very apparent. Well, 3 years later, Congress never quits. This is bad Congress. So what they do is they put a prohibitive tax on the same goods. And now you can't sell them into state commerce because the tax will kill you. And what they did is they struck that down on the grounds that the two things were in parallel. Now, you may expand the Commerce Clause after 1937, but you never got rid of the parallelism. And Justice Roberts missed that fundamental structure. Because you never want to have a situation when two things which are close substitutes, direct regulation and taxation, are subject to different legal regimes. And the earlier guys got that right. And if he had gotten that right, he would have had to come out the opposite way. It may sound like a technical point, but it's very different from broccoli as far as I'm concerned. And in fact, the worst enemy of a good classical liberal theory is some kind of ingenious conservative argument which starts taking these silly examples and treating them as though they have structural significance.